Good evening, good evening, good evening. Thank you guys for joining me today. I really, truly appreciate the support on behalf of Word on the Street Talk TV Worldwide and Fcn Watchdog Media. I really thank you guys that are tuning in, and thank you for the continued support that we've received throughout this whole situation that we've been faced with. Please like, share, comment. Don't forget to subscribe if you have not done so yet to our YouTube channel, Fcn Watchdog Media. We're all over Facebook. We're on YouTube. We're on Twitter. I mean, just about any platform. If you type in Fcn Watchdog Media, you will see our civil rights organization pop up. And if you choose to donate to our organization, you can do so by using our cash tag at donate KNSMIN. All right, tonight we're going to go over the motion that was just filed today in the Supreme Court of Ohio regarding State Farm Fire and Casualty. We did request and ask the court for some certain things today, and I want to cover that with you guys. So we're going to go ahead and cover the motion that was filed with the Supreme Court today. In the Supreme Court of Ohio, Marquis L. Kimble versus State Farm Fire and Casualty Company. Relators motion for sanctions to strike defective filings and for other appropriate relief. Now comes Marquis L. Kimble, relator, pro se, and respectfully moves this honorable court under Rule 313 of the Supreme Court Rules of Practice, Ohio Civil Rules 11, RC 232151, and the court's inherent authority for orders as follows: imposing sanctions for frivolous and improper conduct by State Farm Fire and Casualty Company and counsel, including but not limited to misrepresentation, misleading argument, and incomplete disclosures in their pleadings, patterns of procedural delay, failure to comply with mandatory service requirements, striking respondents' defective filings for noncompliance with Supreme Court rules, Supreme Court Practice Rule 313, and Civil Rule 11, deeming allegations admitted and awarding appropriate relief on following grounds: State Farm's documented bad faith conduct, procedural abuse of the mutual dismissal and suppression of evidence, non-disclosure of Agent Jeff Lambert's unauthorized privacy violations, referring counsel for disciplinary investigation under Rule of Professional Conduct 3.3 and 8.4 for possible violations of candor to the tribunal and conduct prejudicial to the administration of justice. Memorandum in support. Procedural posture. Relator incorporates by reference all prior Supreme Court filings and exhibits 80 through 85A, which detail racially motivated vandalism and ensuing business interruption, a promptly filed State Farm claim frustrated by non-payment and procedural neglect, later wrongful conversion and dispossession of business assets during the adjusted claim period, orchestration of a mutual dismissal and underlying litigation, see Exhibit 82A, in exchange for an admission of privacy violations by a State Farm agent, an admission promised but never delivered. We talked about that. The scamified attorney, Zach DeSilvis, supposedly worked out a settlement agreement with Deborah McSorley. And the settlement agreement was I would sign off the property and give her back the property and give her back possession of the property that we purchased on land contract, recorded with the village of Swanton, mind you. But I would give her back possession of the property, and in return, she would give us a admission of who at State Farm disclosed personal information to her about our claim. Well, we signed and gave the property back, but some kind of a scamified hippie horse scam. She never admitted or never did, kept up her end of the bargain. How does that happen? So we agreed to a mutual dismissal, Mr. De Silvis, but yet you don't hold her feet to the fire for what she agreed to do, that you orchestrated, you scam, and then you made it so that we could never proceed after her again legally. You scamified scam. Zach De Silvis, Shinover Law Firm. It's a scam. Don't hire those scams. He walked our case right out of court. Legal standard. Ohio Supreme Court rules in Civil Rule 11 require all filings be signed, properly served, and well-grounded in fact and law. Rule 313 permits the court to strike documents filed by attorneys who do not comply with the rules, and to issue any sanction as the Supreme Court considers just. RC 2323-51 provides for sanctions where conduct is intended merely to harass, delay, or needlessly increase litigation costs. Rule of Professional Conduct 3.3 and 8.4 prohibit misrepresentation and misleading the court. How did State Farm do this? Well, way back, I think it was way back when we were somewhere around exhibit 11 or 13, the court notified me that State Farm filed a motion to dismiss. That's perfectly fine, because as soon as they filed the motion to dismiss, I filed a response with the court. And then I did the proper thing, which is notify the defendants and their attorneys that I filed a response to their dismissal. Well, then after about 20 minutes after I sent the scams my response, serving them as I'm supposed to, State Farm then sends their notification of service of the dismissal 20 minutes after I already filed a response and served them. Complete violation of the Supreme Court rules, flat out. How are you even an attorney and you're just violating the rules and it's not being called? You should be disbarred for that, you scam. Attorney Lori Thompson for State Farm, she's a scam. Works for Gallagher, Gams, Talon, and Barnes out of Columbus. She tried to sneak in a filing and lied to the docket, lied to the court, told on the court's paper that she filed that she served me when she didn't. That's a lie, and that's misleading the court. And you will be held accountable for that, State Farm. Basis for sanctions: misrepresentation, concealment, and failure to provide admission. State Farm failed to ensure its agent privacy breach was remedied and concealed material information central to the insurance and the court's review. Respondents' filings do not fully or accurately reflect the facts and exhibits established. Abuse of mutual dismissal and suppression of rights. Responded through adverse counsel and without the mandated admission, obtained a permanent case closure affecting substantial property rights, all while misusing Civil Rule 41A1B to avoid judicial scrutiny of State Farm's own statutory and regulatory violations. This is improper under both Supreme Court authority and the Ohio Rules of Civil Procedure. Bad faith, delay, and procedural evasion. Repeated refusal to admit undisputed facts and exclusion of material evidence are part of a deliberate effort to protract litigation and prejudice, relate to an unrepresented civil rights litigant in violation of established insured duties, Supreme Court precedent, and the public interest. Relief requested: Relator requests that this court strike State Farm's non-compliant filings, including any document found to misrepresent, withhold, or delay material facts. Impose sanctions as provided by Rule 313, Civil Rule 11, and RC 232351. This may include, but is not limited to, default or limitation of defense, an award of fees and costs, further referral for disciplinary proceedings. Deem relator's material allegations as admitted. Purpose of this mandamus, and move directly to consideration of the merits of relief. Order such other and further relief as is just and appropriate. Conclusion. By this motion and the massive unrefuted record, relate to request that the Ohio Supreme Court uphold its supervisory and disciplinary function, holding respondent and its counsel to account for procedural abuses and statutory violations that have lasted since 2022 and continue to harm the administration of justice for civil rights litigants in Ohio. That, my friends, concludes the, us covering what we filed in court today. Please like, share, comment. Don't forget to subscribe. And don't hire State Farm. It is a scam. Until next time, be blessed on purpose.